Welcome back to the Toy Report. In a surprising twist, a federal judge from Texas has hit the brakes on President Biden's new pistol regulations thanks to a lawsuit brought by passionate gun rights activists. Judge Drew B. Tipton of the U.S. District Court for the Southern District of Texas has granted a preliminary injunction against the ATF, putting a partial halt on the enforcement of their strict stabilizing brace rule. This ruling follows a similar decision by the Fifth Circuit Court of Appeals, where the ATF was told not to enforce the rule against plaintiffs, including customers of Maxim Defense Industries and the Firearms Policy Coalition. The timing couldn't have been better, just days before the registration deadline for pistol braces with the ATF. In this legal showdown, the state of Texas has stepped into the ring, making things a bit more interesting. Led by the former Texas Attorney General Ken Paxton, they've launched a motion to put the ATF's pistol brace rule on hold. Their argument: this rule will burden Texas police who own handguns, stabilizing braces, forcing them to jump through hoops and spend precious resources just to register their weapons. Judge Tipton gave Texas a nod of approval, acknowledging their right to sue the ATF and agreeing that they would face irreparable harm without a preliminary injunction. It's a classic case of everything's bigger in Texas, even legal battles. The pistol brace rule itself was born out of Brandon's grand plan to tackle gun crime, which he unveiled after the tragic incident in a Boulder grocery store, where a gunman used a firearm equipped with a stabilizing brace to take innocent lives. Another horrific shooting in Dayton, Ohio back in 2019 also involved a similar brace. These incidents have fueled the push for tighter regulations, but now Texas is putting up a fight, arguing that the rule unfairly targets responsible gun owners and causes unnecessary headaches. The ATF sure has a way with words when it comes to defining stabilizing braces. According to them, it's an accessory that lets you fire a weapon from the shoulder as long as it looks like it's meant to be fired from the shoulder. Clear as mud, right? Their new rule, which they've been excitedly waving around since January, slaps the short-barreled rifle label on pistols with these braces. Why? Well, apparently, these pistols are accurate and concealable, a combo that screams dangerous to Congress. President Biden even chimed in, accusing the gun industry of trying to outsmart the system by selling these braces that can magically transform pistols into short-barreled rifles. It's like they're playing a game of regulatory hide-and-seek. According to the ATF, there are a whopping 3 million guns with stabilizing braces out there in the good old US of A. But hold on, wait for it. The Congressional Research Service thinks there could be anywhere from 10 million to a staggering 40 million of these bad boys floating around. Brace yourselves, folks. That's a whole lot of braces. Not surprisingly, gun rights groups have taken the ATF to court, arguing that this whole stabilizing brace rule thingy violates the Constitution. They claim it forces millions of law-abiding gun owners to register their weapons or risk being branded as felons. It's a legal battle for the ages, with the Constitution as a star witness. In the midst of all this legal drama, Judge Tipton swooped in with his injunction, waving his mighty gavel around. The order applies to all those lucky folks employed by the state of Texas or its agencies, as well as the members of Gun Owners of America. Looks like they caught a break, for now. Let's check out the judge's order, shall we? As usual, I don't want to bore you with lawyer speak, so I'll rephrase everything in layman's terms. But I'll leave a link to the order if you want to read through it. The plaintiffs are asking the court to stop the defendants from enforcing a final rule across the entire country until the case is finished. The court knows that there are other cases where people are challenging the same final rule for the same reasons. In one of those cases, a judge in Texas denied a similar request to stop the enforcement of the rule temporarily. The people who filed that case appealed the judge's decision and asked for the rule to be stopped while the appeal is happening. A panel of judges from the Fifth Circuit Court of Appeals agreed to temporarily stop the rule from being enforced while they review the district court's decision. At first, the temporary stop only applied to the people who filed the case, but a few days later, the Fifth Circuit clarified that it also applies to the customers and members represented by the plaintiffs from the beginning of the case, as well as the individual plaintiffs' resident family members. The court believes that the same help given to the plaintiffs in the mock case is appropriate for the private plaintiffs in this case. This is because the request made in the mock case and the request made in this case are very similar. Both requests ask the court to stop the enforcement of the final rule because it goes against the Administrative Procedure Act and the Second Amendment. Although the plaintiffs in this case bring up some arguments that were not mentioned in the mock case, the outcome of that appeal will likely have a significant impact on, if not completely influence, the court's decision in this case. One notable difference between the mock case and the current case is that the state of Texas is a plaintiff in this case, along with the private plaintiffs. In order to decide whether Texas can be granted the relief they are seeking, the court must first determine if Texas has met the requirements of Article 3 standing, which relates to having a valid legal claim, and then consider if Texas has provided enough evidence of significant harm that cannot be fixed. In order for Texas to have standing, it needs to show three things. 1. It suffered a real injury directly caused by the defendant's actions. 2. The injury is connected to the defendant's actions. And 3. A favorable court decision is likely to fix the injury. The only element that is in question here is the first one, whether Texas can prove it has experienced a concrete and specific violation of its legally protected rights, rather than something hypothetical or speculative. The court concludes that the costs Texas will have to bear in order to comply with the final rule are enough to satisfy the injury requirement for standing. This means that the expenses Texas will face in registering previously legal handguns with stabilizing braces are considered a valid injury. The court refers to evidence showing that it takes about 30 minutes to complete a registration application with a cost of $49.67 per hour, resulting in a burden of $25 per application. It's worth mentioning that Texas doesn't explicitly say they have parens patriae standing, which is when a state sues on behalf of its residents. However, the court interprets Texas's arguments as if they were claiming parens patriae standing because they're talking about an injury to the well-being of their residents. But here's the twist. The court decides that Texas cannot establish standing using parens patriae based on previous legal decisions. However, Texas has managed to show standing by demonstrating the costs they'll incur to comply with the new rules. Now that Texas has shown its standing to bring this case, the court needs to determine if Texas has presented enough evidence of irreparable harm. In order to grant a preliminary injunction, Texas must demonstrate that it will likely suffer harm that cannot be fixed later if the injunction is not granted. Texas claims three types of irreparable harm related to the final rule: harm to its quasi-sovereign interests, and unrecoverable compliance costs for some of its employees. Regarding its sovereign interests, Texas argues that the final rule undermines Texas law and federalism principles. However, because the Texas state law definition of short-barrel firearm remains unchanged, Texas is not compelled to modify or stop enforcing its own laws. Texas is making a case that it has a special interest in making sure people can use pistol braces safely. They call it a quasi-sovereign interest, but here's the thing. Texas hasn't provided enough evidence to support this claim. They haven't met the legal requirements to assert this kind of interest, which is called parens patriae standing. Even if the court were to consider parens patriae standing, Texas still hasn't shown that they have a unique interest in this particular situation. But when it comes to the compliance costs, the court finds that Texas has demonstrated it's likely to suffer irreparable harm if a preliminary injunction is not granted. Based on the above analysis, the court concludes that Texas has met the requirements for Article 3 standing and has shown sufficient evidence that it will suffer irreparable harm if a preliminary injunction is not issued to stop the enforcement of the final rule. As a result of the court's decision, the plaintiff's request for a preliminary injunction has been partially granted. The defendants are now prohibited from enforcing the final rule against the private plaintiffs in this case, including their current members and their family members living with them. Additionally, individuals who are directly employed by the state of Texas or its agencies are also protected by this injunction. The injunction will remain in effect until the expedited appeal in the Mock v. Garland case is resolved. So ordered. Signed on May 31, 2023 by District Judge Drew B. Tipton. And regrettably, that's all the time we have for today. If you have family and friends living in Texas, share this video with them so they're aware of this order. Please like, subscribe, and click on the bell icon so you don't miss out on the latest Second Amendment news. Thanks for watching, and you have a good one.